Good evening, everyone. I'm Thane Rosenbaum. I'm the creative director of the Forum on Life, Culture, and Society at Touro College, and welcome to the inaugural series, FOLCS series, now called Headlines. We've added yet another dimension to the FOLCS cavalcade of stars and issues that we undertake. This is an idea that came to us, frankly, from one of our board chairs, Jeffrey Lenoble, and it's a great idea. Issues that are topical and timely, that have social, political, cultural, and legal significance and are of the very moment are ripped from the headlines into what we now call the FOLCS Headline series. So we're adding that to our FOLCS Conversation series and our FOLCS Film series and our various other programs. And you may all know, because those of you who tuned in probably have an enormous interest, there was an abortion case argued last week from Mississippi before the Supreme Court, and there are all sorts of questions related to that. What does this do to Roe v. Wade? Does this seem like the court is becoming overly politicized? Are the Trump justices going to do what exactly he said he would do, which is overturn Roe v. Wade? The case is called Dobbs versus Jackson, and it has gotten a lot of people talking because there's just a lot of questions in the public square. And of course, by doing so, we're wading into treacherous political territory. Reproductive freedom, abortion rights, the autonomy of the body, something that's very important going back to the founding fathers. That's our liberty and autonomy rights, and yet the right to life, right? And that issue we had thought was resolved, but it's never been resolved politically. And now we're not sure it's been resolved legally. Is what right controls, the right to terminate a pregnancy or the right to life? To discuss this tonight is our old friend, Adam Liptak. Hey, Adam, welcome. Thanks for joining. Many people know Adam. He's the Supreme Court correspondent for the New York Times. Prior to that, he was the National Legal Affairs correspondent for the New York Times. Prior to that, he was a First Amendment attorney for the New York Times. Prior to that, he was a First Amendment attorney at a Wall Street law firm, but he's always been a friend of FOLCS. In fact, he's part of our history. Our very first event, I think it's like 2006, 2007, with Tony Kushner and the novelist E.L. Doctorow. I don't know if he remembers it, but he wrote about it the very next morning for the New York Times art section. And that's how we started. And we thought, wow, what a great beginning. We started when our first event was covered by the New York Times in the front page of the art section. So we always thanked Adam for that. And he's always been part of our series, Law of the Land. Hopefully he'll be back with us. That series always takes place after July 4th weekend, when the end of the conclusion of the Supreme Court term, where we do an annual survey of the Supreme Court cases. If you're watching us live on Facebook, welcome. We love having you. Make sure you come to folks.org and give us your email address so we can give you advance notice of other programs. If you have a question for Adam, you can go to the Q&A box. And now let's start. Adam, welcome. Thank you. So the first question, before we even get to this Mississippi case, you're back at the court. I think most people don't realize last year's term was all done by telephone. The Supreme Court justices forgot what each other looked like for a year. They didn't see each other the entire 2 terms, and even part of the prior term in 2020, right? I think they stopped in April of that. And then all of last year was all telephonic. Now we're back inside. Tell us what it's like to return.
Well, it's a great pleasure to get out of the house. So I'm enjoying going to court. It's different. The courtroom is still closed to the public. The roughly 25 journalists who have full-time press credentials, so-called hard passes, are allowed into the courtroom. We have to be tested every week. We have to wear N95 masks. And we're not seated where we usually are, which is in these kind of 2 church pews to the left side of the court. We're seated in the public section. The public is not allowed. And we're socially distanced, so it's a little hard to gossip with my friends in the press corps before the argument starts. And then when the argument does start, the lawyers are masked except when they're arguing. The justices are not, with the exception of Justice Sotomayor. And you sort of, when you're saying,
you're saying they're not even when they're just listening, and they're not.
That's right.
Right.
They're tested quite regularly, and Justice Kavanaugh tested positive not so long ago and sat out for a week or 2. but you kind of feel exposed. I kind of like being off to the side. Here it's it's not the biggest room in the world to begin with, and it's basically just us and them. And you sort of feel that if you wrote something a little sharp about one of them the night before, the day before, you might be getting the stink eye in the morning.
Yeah. Now the pandemic did a number of changes, right? Innovations. They went telephonically, but telephonically for the world to hear. Everyone could hear it. Is that still the case?
Yes. So there continues to be live audio, and we're rapidly getting used to live audio, but it would have been unheard of, if not unthinkable, before the pandemic. The practice at the court had been for years to release audio at the end of the week, just long enough so that it's no longer newsworthy. And then on about 20 occasions in the past 2 decades, there's been same-day audio. But live audio is completely a creation of the pandemic, where, as you say, Thane, for the entire last term, the term that ended this June, it was all telephonic. And moreover, the way the argument was conducted changed. The classic Supreme Court argument is a free-for-all. Justices lobbing questions, interrupting each other, interrupting the lawyers. And to my mind, we can talk about this more, that's a very productive kind of free-for-all.
In part, I'll maybe explain, because sometimes the justice doesn't need to know the answer. He or she is making a point to another justice and using the lawyer, right? I mean, sometimes they know the answer. They're like trying to embarrass a lawyer to make a point to change the opinion of one of their brethren.
The form of the argument is, I'm asking the lawyer a question and I'm seeking a legal view or a bit of factual information. The reality of it is, as you say, Thane, is they haven't talked about the case before the argument, and they're talking to each other. They're trying to persuade each other to adopt a point of view. So that John Roberts, who's, before he was Chief Justice, he was a very prominent Supreme Court advocate, used to say that the role of the lawyer is to be like a basketball backboard and just, stand there while the justices bounce questions off each other. So that bouncing questions off each other kind of receded during the pandemic, during the telephone arguments, where to make it work, they really had to go to a more rigid, structured system where they would ask questions one at a time for 2 or 3 minutes each in order of seniority in lockstep. And I found that to be not very satisfying at all.
But it did open up something that I think never happened before, right? It forced Justice Thomas, who historically didn't ask any questions. Now he's become an active participant.
Yeah, Justice Thomas once went a decade without asking a question. It's very, very rare. And now, in essence, the microphone is handed to him and he wasn't prepared to say, I pass. So he asked questions, and he asked good questions. And it was, a distinct positive aspect of this otherwise not very satisfying mode of asking questions, that he became a participant in this significant public life of the court. Now that we're back in the courtroom, we have, you might say, the best of both worlds. We're back to 30 minutes aside of free-for-all, but not entirely free-for-all, because the court has adopted this odd custom of letting Justice Thomas go first. So almost without exception, even in the free-for-all part of the argument, he asked the first question or two. And then after each lawyer gets their allotted 30 minutes, typically, there's a round of lockstep questioning where each justice has the opportunity, many of them don't take it, but to ask a follow-up question, which maybe they weren't able to get in. And that works fairly well. It does make the arguments longer.
Right.
So the abortion argument we're going to talk about, a religion argument just yesterday, went on for about 2 hours by the time you get all of this stuff in. And that's a long time to pay attention.
But overall, though, what you're describing is something that looks like it has more civility, right? They go lockstep, they go in order, they seem to be more deferential toward each other.
Yeah, that's true. And they care about what people write about them. And there have been studies in particular suggesting that the female justices are more apt to be interrupted, not only by their fellow justices, but by lawyers. Wow. And the court hates that look. Wow. So in both parts of the argument, in the kind of free-for-all and then in the follow-on lockstep, the justices are pretty good about not interrupting each other. But there was this great moment, I think it was last week, where Breyer and Kagan start talking simultaneously. And Breyer, as the senior justice, according to the custom of the court, carries on, but he knows he's in kind of a pickle, and he says, I bet we were going to ask the same question anyway. and Kagan, bless her, says, I doubt it. You know,
and right, and then he went first.
And he went first, and there was laughter. And of course, the idea that Justice Kagan, who is a very distinctive and acute and scalpel-like questioner, should ask the same question.
Right, unlikely.
As the Breyer 3-minute hypothetical,
yeah,
was, at least to some of us, comic.
So this case, the Mississippi case, we're going to try to accomplish a lot in a short period of time. We've had Supreme Court cases that dealt with abortion since 1973's Roe v. Wade, and even since 1992's Casey case. We've had them. What is it that's unique about Mississippi that changes the abortion landscape so dramatically that pro-abortion activists are worried that we could very well see the overturning of Roe v. Wade?
Well, so in light of Roe and Casey, we have established constitutional law, reaffirmed in Casey, that states can regulate abortion in various ways, but one thing they can't do is ban it before fetal viability, before the fetus can survive outside the womb. That's currently around 23 weeks. Now, a lot of red states have nonetheless, in a kind of performative way, passed laws banning abortion at 6 weeks, at 12 weeks, at 15 weeks, and the lower courts routinely strike them down because they're unconstitutional under Roe and Casey. 15 weeks is well before 23 weeks, and that ban can't survive under established constitutional.
And the Supreme Court chose not to hear those cases.
Well, right. The lower courts strike them down, and the Supreme Court has no reason to hear them, unless, of course, they want to do something. So when the court decides to hear this case, the Dobbs case, abortion rights supporters are justifiably nervous, because why did they take it except to do something? And they struggled on the question of whether to take it. Ordinarily, the court decides not to hear a case right away, or sets it down for a second private conference or a third private conference, and then decides not to hear it or to hear it. This one must have been conferenced a dozen times, and they were really struggling with whether to hear it. And when they decided to hear it, abortion rights supporters got nervous.
So what's at stake, Adam? Is it that the moving of the goalpost from 24 weeks to 15 weeks? Or is it the actual right itself to have an abortion? It seems confusing. For instance, you said the word viability. Does this mean that Mississippi is saying that the science and technology now allows a fetus to be viable after 15 weeks?
No, they're certainly not saying that. Nobody thinks that.
So is the issue here simply that this time a state's attempt to reduce the move from 24 to 15, the Supreme Court wanted to hear that. And that alone is threatening, even if they don't overturn Roe v. Wade, or must they overturn Roe v. Wade if they choose to uphold the Mississippi law?
So that depends on whom you're listening to. There are basically three possible outcomes in the case. One is they strike down the Mississippi law. That's very unlikely. They didn't take this case, as you were suggesting, they didn't strike it down. The second is that they say they're upholding the 15-week law, but not overruling Roe. Many people think that's impossible to do, because Casey itself says the core holding of Roe, the essential holding of Roe, the central holding of Roe is you can't ban abortion before fetal viability. So these people would say, if they say yes to 15 weeks, they're effectively overruling Roe. But the third option is to overrule Roe in so many words. And that matters in part because there are a dozen states that would outlaw abortion entirely and have so-called trigger laws in place that says as soon as the Supreme Court overrules Roe, we're going to ban abortion entirely. So the three outcomes: strike down law, sustain it at 15 weeks, but not overrule Roe in so many words, and overrule it in so many words are kind of different. And at the argument, the Chief Justice, at least, was trying hard to redraw the line at 15 weeks, but not go to 0.
So he would say, because it seems like, and your reporting seemed to suggest this, that he was wondering with the lawyers, can we simply go to 15 and retain the underlying principles of the right to privacy and the right to have an abortion? And so that he was taking that second position that you're describing.
Yes. So here are some things to be said in favor of 15 weeks. About 95% of women get abortions before 15 weeks.
13 usually, right?
Well, some quite early, some later, but
right. But I'm saying Mississippi's position is it's even earlier than 15, right?
Yes,
yeah.
Right. And the sole clinic in Mississippi will only, by choice, but will only do abortions to 16 weeks. So the difference between 15 and 16, not that large. Public opinion polling suggests that the public is comfortable in that zone, 12 or 15 weeks. And the international experience in much of Europe is 12 weeks. Although the social context is very different, the state will pay for the abortion.
Yeah.
You don't have all kinds of obstacles to abortion. So I'm not endorsing this point of view, but those are some things to be said in favor of 15 weeks. Things to be said against it is it's hard to know what the constitutional principle is. If you throw viability overboard, you don't know what you're left with. And what abortion rights supporters are very afraid of is if you say 15 weeks, what's to stop the court from coming back next year and saying 12 weeks? And the year after that to say 6 weeks. And there's no logical stopping point, they would say, once you overthrow the core principle of Roe, which is fetal viability.
So one of the things I think our audience, especially those who are not lawyers, and most are not, should understand, given what you're saying, and why don't you correct me if I'm wrong, is that at the very beginning with Roe v. Wade, the understanding was we are granting a right to privacy. A woman has a right to privacy, but we recognize that the state also has an interest at some point to regulate or preserve life after 24 weeks. So that essentially it did both things. It literally split the baby, right? It didn't just say there's a right to an abortion. It also said that the state has rights also. And that's why you're saying, what's the constitutional principle that's after that? Because the whole point was viability was the standard after which the state's interest enters into the picture. So when does the state's interest now? For 15 weeks? And why is it the 15 weeks that the state all of a sudden has a right?
Well, bear in mind that Roe itself had a different schematic than simply viability and a trimester system.
Right, exactly.
And in the trimester system, the state was essentially powerless to regulate abortion in any way in the first trimester up to about 13 weeks. It could regulate on behalf of, to preserve the health of the mother in the second trimester, and only up to about, call it 26 weeks. And then only in the final trimester could it, in the interest of preserving fetal life, ban abortion so long as there were exceptions for the life and health of the mother.
Right, but I'm just saying that people need to know that Roe v. Wade doesn't say it's an absolute right to an abortion.
That's true. And the point I was making is that that trimester system was thrown overboard
anyway
in Casey. So,
yeah.
And Casey comes up with the undue burden standard,
right?
Saying, I mean, it retains viability as the key cutoff, but it doesn't call for the kind of searching judicial scrutiny of restrictions that lawyers call strict scrutiny that Roe called for. and imposes a more relaxed standard of an undue burden, saying before viability, states can regulate but not ban abortion so long as it doesn't place an undue burden on the right.
So the Mississippi case, apparently, originally, when it was first being briefed, said, I guess it was the Attorney General of Mississippi, oh, no, don't worry. We're not seeking to overturn Roe v. Wade. We think Roe v. Wade is settled law. I don't know what they actually said, but they said, but we just really want to move the goalpost from 24 to 15, right? But then they changed their position and now have been arguing that, in fact, Roe v. Wade is unconstitutional. There's nothing in the Constitution that grants a right to abortion. So my one question is, were some of the justices pissed off? Did they say, what the hell are you doing? You said you weren't going to, now you're arguing overturn Roe v. Wade.
Yeah, you're right, Thane. In its petition seeking review, it said that ruling in favor of Mississippi would not require overturning Roe and Casey. And it drops a footnote, the petition seeking review, saying, but of course you can if you want to. And then when the court accepts review of the case, all of a sudden it's full on. There's really no principled way to do this except to overrule Roe entirely. At the argument, that didn't get a lot of play. The Chief Justice did ask a question saying that, Mr. Solicitor General Scott Stewart from Mississippi, would you care to say a word or two about what seems to be an apparent change in your position? And he said a word or two, but it didn't seem that the court was going to do anything in response to this. It has the power to, in the jargon, dig a case, dismiss as improvidently granted.
Yeah.
A case in which the parties changed position. That doesn't seem to be where it's heading.
Yeah, I mean, I wondered whether something like that procedurally could have happened. Like, go back and do it again because you've contradicted yourself. Now, did they do this, Adam? I hate to say the word politically, but politically, did they say, oh my God, since we first established this law, there are now 3 justices appointed by Donald Trump, and we've got the other side on the run. Let's just go full bore and say, let's end Roe v. Wade. Is that why they did it? They became emboldened?
I think the replacement of Justice Ruth Bader Ginsburg by Justice Amy Coney Barrett sure helped shape their thinking. And you could call it political, you could call it strategic, but their hand got better. They drew another card and their hand got better.
So let's talk about this idea about they're talking about overturning Roe v. Wade. We know there, at least Thomas, I guess, and Alito, and probably even Gorsuch, probably think right now before the argument that there's nothing in the Constitution that grants a woman a right to an abortion. And so they already have 3 votes. They only need 2 more. They could pull Amy Coney Barrett or Kavanaugh. They don't even need Roberts anymore. I guess what I want the audience to understand is that it is true that abortion is silent in the Constitution. It's not like freedom of speech or the right to religion or even the Second Amendment right to bear arms, that there was a lot of, it depends on who you ask, right? Judicial contrivances, or that this is a legitimate reading of the Constitution that granted a series of privacy rights that aren't actually in there, but are read into it. And one of those rights is abortion.
So there's a couple ways to think about it. But it's true that this right to privacy, as Justice William O. Douglas famously said, is a result of penumbras and emanations from various constitutional provisions.
Like shadows. Yeah,
but the Constitution does care about privacy in the Fourth Amendment setting, and in the Third Amendment. And you can construct privacy rights out of that, but probably the better place to put it, and Casey does get there, is in the due process right to liberty. And then separately, and this is what Ruth Bader Ginsburg would say, who was never happy with the reasoning in Roe, in order for women to be full participants in the life of the nation and to have dignity and autonomy, they really need, she would say, access to abortion care. And that's a component then of the Equal Protection Clause.
I see.
So it's true that the word abortion doesn't appear in the Constitution, but it's not an especially heavy lift from certain jurisprudential perspectives to find it in the Constitution.
So if we end up here reading this case at some point, are we likely to read either concurrences or majority opinion, depending upon how it works out, or dissents, in which Thomas or Alito or maybe Gorsuch says that Roe was wrong at the outset, that what is being described by Douglas and what Ruth Bader Ginsburg was talking about for equal protection, it simply doesn't exist, that it is a contrivance. And that's why we are taking this very extraordinary step of uncoiling everything that happened after 1973.
I agree with you that those three justices almost certainly, if this issue came to them fresh, and even in the current setting, believe that the abortion has the Constitution has nothing to say about abortion. I think the other three conservatives, Roberts, Barrett, and Kavanaugh, share that view. And the question is, and the briefing on the abortion rights side was almost entirely centered on, was, okay, even assuming the Constitution doesn't speak to abortion, we've had 50 years of precedent on precedent. Doesn't that deserve respect? Doesn't that have the force of what lawyers call stare decisis, legal Latin for to stand by things decided? And the battleground really is not on this ultimate question of what does the Constitution say. It's about, do we respect 50 years of precedent that generations of women have come to rely on?
And is there also maybe, I don't know if this came up, but like a reliance interest, right? That it's not just that this is established precedent, but that women or citizens of this country, more than half the country, had the right to rely over 50 years on this principle. And now you can't just undo this principle because they've been living, 2 generations already have come through with this right.
It was certainly heavily discussed in the briefing, and reliance is a standard part of a stare decisis analysis. And you can think of reliance in 2 ways, I suppose. One is it a 9-month window? Or the second is, have you structured your life around that you're planning to have children at a certain time and not at another time? And withdrawing that right will fundamentally alter your ability to structure your existence and your family planning.
But I was wondering, it's interesting that you point that out, because I wonder, is that what Barrett was getting at when she talked about adoptions? Because it made me think, in 1973, I was alive in those days. I remember those days. It was the beginning of the women's liberation movement. There was lots of fervor, upheaval about the rights of women, the equal rights of women. And the idea was, as what Ruth Bader Ginsburg saying, in order to be a full participant in our society, we have to be able to get jobs and live our lives and have the right to, over our bodies. But was Barrett saying, hey, look, we're not in 1973. In the year 2021, we have women who are partners at major law firms. They're partners at Goldman Sachs. They have full careers. They have house care help, and you could always adopt. Right? It wasn't that her point that having the right, the reproductive freedom, doesn't mean that there are no other options, because there are, and we've proven it over the last 50 years.
Yeah, so Barrett is the only mother on the court. She has 7 children, 2 of them adopted. And the point she made, which struck a lot of people as interesting, was she repeatedly referred to so-called safe haven laws, which allow you to turn over your baby after the baby is born at the local hospital and without legal consequence. And she made the point that she's not saying that, a forced pregnancy is something, but we don't live in an age of forced parenthood because all 50 states have these safe haven laws. And many people thought that comment was curious for at least two reasons. One is, forcing a woman to spend the better part of a year bearing a child is no small thing. And the other is, it's also no small thing having given birth and formed the attachments that naturally follow from that, then to turn over another human being to the state.
So it's interesting. In 1973, people who were opposed to abortion would say the court was engaged in judicial activism. And today, the same argument is being made in reverse, right? The undoing of the right to abortion is an example of judicial activism. And that was sort of what I think Sotomayor was saying when she said stench. She was saying, do people understand the implications for the public? We already have low polling numbers. Only 40% of the country actually thinks we're doing a good job. And now we're going to undo Roe v. Wade. They're going to think we don't even know what the law is, that we had a law for 50 years and we never really understood what it was. And now we're changing it back. Is that really what this is? Is she talking about? It's ironic because it is, in a way, there's two faces of judicial activism, both the beginning, the creation of the right, and the taking away of the right.
Yes, so judicial activism is hard to define, and it often just means you don't like the decision. But political scientists do have two measures of judicial activism, and both of them figure in this thing. One is overturning a decision of the political branches. And Roe did overturn abortion laws in many, many states. And in that sense, it was activist.
Right.
But the second measure that political scientists use is overturning precedent. And they also say it's activist to overturn precedent. And now that we have 50 years of precedent, it would be a different kind of activism for the court to do that. And, Sotomayor's comment, which was so bitter, asked the question of, can the court survive this blow to its legitimacy? And, the court has survived a lot of things. And the court is still held in much higher regard than the presidency or Congress or lawyers or journalists.
Right.
But its public approval ratings have been dropping pretty fast. And we haven't talked about, and maybe we won't talk about, but the other abortion case that's
I'll definitely get to that, hopefully.
But the court's refusal to block the Texas abortion law at 6 weeks has seemingly really damaged its reputation.
Right, and I'm going to have you soon explain what the court. No, because I think it's important because it was very clever lawyering. This is the kind of thing that that law professors just love, right? That Texas actually pulled a shrouded, right? They came up with a very interesting way to make it so that the court would not know what to do with it. So we're going to talk about that, but the reason that people are rejected what the court did over the summer, it's not obvious to most people why the Supreme Court even had a basis to reject taking the case, because something Texas did that made them confused, legitimately confused, and what our role is in this context. But Kavanaugh responded by saying, yeah, well, you maybe you don't like to undo 50 years of precedent, but it doesn't mean you can't, right? For instance, and he gave a list of really important cases. I guess the most important one is Plessy versus Ferguson, which was overturned by Brown versus Board of Education, which desegregated the schools. And I suspect he would be saying, yeah, that was an established precedent that people could rely on, and aren't you happy we got rid of it? So he gave a list of other such cases. Did that seem to, did any of the more liberal justices have a response to that?
I don't know if they had the response on the spot, although maybe they did, but others have had the responses. That's true. There are many towering cases, really important cases that overturned precedent, but they all overturned them in the direction of expanding rights. And it would be probably a first, I think a first. I mean, another example is Lawrence against Texas. which overruled a case that criminalized gay sex. And there are many examples, but they all seem to move in the direction of making people freer. If we have Roe overruled, many people will say that it's the first decision to overrule in the direction of subtracting rights. Now that puts to one side the interest in fetal life. I get that.
So before we get to the next question, I think this is a good moment to just tell the audience that what you just said, Texas versus Lawrence, the case that overturned a Texas statute that criminalized gay sex, that too was in a kind of panoply of cases that were part of what we now call the right to privacy. So this right to privacy that Adam was explaining before and where it comes from ultimately gave birth, sorry, bad pun, but gave birth to a number of different cases, not just the right to an abortion, but also the right to gay sex, the right to same-sex marriage, the right to contraception. It may be that Thomas and Alito don't agree with those rights either, right? They would undo all of those rights because they would say it's not in the Constitution, right?
That's right. Although my own view is, and Justice Barrett asked some questions along these lines of the lawyer from Mississippi, her point was, now if we overrule Roe, we don't have to overrule all this other stuff. And the lawyer said no. And it does seem to me that those decisions have been accepted by the public in a way, whatever their constitutional pedigree, that they've been accepted by the public in a way that it's hard to imagine them being overturned. Whereas Roe, say what you will about whether it was correct or not, has been controversial for the past 50 years.
So you're saying even same-sex marriage in your mind has more of a wider public acceptance than Roe v. Wade?
I do believe that. I think the polling reflects that. I think with each passing year, there's a significant minority in the country that objects to it, but with each passing year, it's more accepted. And we talked about reliance interests before. The reliance interest in staying married is pretty high. So it's very hard to imagine that the court could withdraw that.
And certainly the use of contraception, clearly that, even the right to gay sex, even I would think you would say even more strongly is accepted, wide, more of a consensus. Yes. And you're right, I hadn't thought about it before, that for whatever reason, our country and the issue of abortion is just very loaded politically, morally, legally. And so it's not surprising that everyone last week had great trepidation about that oral argument.
Just a quick point about Roe, it's become very controversial. It wasn't super controversial when decided. It was a 7-2 decision. A number of Nixon appointees were in the majority. A Nixon appointee, Harry Blackmun, wrote it. And it sort of galvanized the other side, but it took them a few years to get going. When John Paul Stevens was nominated to the court in 1975, at his confirmation hearing, he got no questions about Roe. So it took a while for people to get upset about it.
Really? So it picked up more opposition. It's interesting. I'm wondering whether the 1980s, with the rise of the moral majority, that political movement might have had something to do with it.
It also is possible, and Ruth Bader Ginsburg, who of course supported abortion rights, used to say this, that Roe did too much too fast, that it should have struck down a very restrictive Texas law, but it didn't need to strike down all the laws nationwide. It could have moved slower. It could have let there be a legislative response. And the court's relatively slow movement on same-sex marriage might have reflected that more deliberate process and not done what Ginsburg said Roe did, which is do too much too fast.
And I think the audience should know that what Bader Ginsburg said is, generally speaking, what the court does, make incremental changes, yes. Right? That before there was Brown versus Board of Education, there were other cases that were taken up, so that this concept of chipping away is something that is part of the whole experience. By the way, I can just give you To Kill a Mockingbird is still, and since our FOLCS has a cultural dimension to it, To Kill a Mockingbird is still on Broadway. when people wonder why it is that Atticus Finch is not as upset by the verdict in To Kill a Mockingbird, there are people who have said, I have been one of them, said, well, because he went to law school and he knows that the fact that the jury held out for 30 minutes, that Mr. Cunningham held out, that was a big deal. And it may not seem like a big deal, but Atticus Finch said, well, I think this is a step that might lead us to Martin Luther King and the Voting Rights Act and the Civil Rights Act, that this concept of incrementalism is something that's endemic to our legal system.
Right, and which is why I would have thought before the argument in the Mississippi case that the court would take a step and go to 15 weeks. By the conclusion of the argument, we'll see. It seemed as likely that they'll simply overrule Roe.
Okay, so but before we get to the Texas case, just to explain to the audience, if this is an if, not in any way, this is not my perspective or my desire, but if Roe v. Wade were to be officially overturned by Dobbs versus Jackson, what some of the justices said was, well, it just returns a political issue, which is very politicized, to the states and let the states decide for themselves. It doesn't mean that abortions will be illegal. It means that they'll be illegal in some states. Now, I realize that is hardly a concession to someone who doesn't want to go from Mississippi to New York to have an abortion. I understand that. But I think that most people don't understand that the overturning of Roe v. Wade doesn't necessarily mean that abortion will be legal everywhere, right? It doesn't. It just means that as a constitutional issue, we're not recognizing a right to privacy in an abortion. Is that what would happen, or would the states say, the states that allow abortions, would they recognize a right to a privacy that emanates out of the right to autonomy and reproductive freedom?
So if Roe is overturned, maybe 22 red states would make abortion essentially illegal. And that would mean that rich women in those states could travel elsewhere and get abortions, and poor women couldn't. Yeah. And the number of legal abortions would drop, and the number of illegal and dangerous abortions would rise. So it'd be hugely consequential, but it wouldn't require states to outlaw abortion. It would let California and New York do whatever they want, and they don't need a constitutional theory. They just need legislation. But it would transform life in America. It would be profoundly disruptive for women in red states. And it would probably represent a political upheaval too, because it's really not clear what would happen. It's like the dog that catches the car. The Republican Party has wanted this for a long time, but it's not at all clear it would be good for Republicans.
You're saying, be careful what you wish for.
Yes. Right.
And of course, I just read just yesterday, California now wants to be a sanctuary state. Is that part of the idea that they recognize that we're going to make one state and we're going to make it financially possible for you to come here and get a free abortion because we're worried that there are not going to be many safe havens? So it would, even if it's possible, even further polarize the nation and sort of create, two Americas. Right.
One that has this right, the other that doesn't.
It would make it even more blue and red than before, right? So let's go back to the Texas case, because it feeds nicely into what we just discussed. Because you said before, hey, there are a lot of states that already have laws called fetal heartbeat laws, like Texas, by the way. Texas is the only state that it's in effect. That's what happened this summer. But the fetal heartbeat law says, forget the 24 weeks, forget the 15 weeks. The minute you can hear a heartbeat, and we're going to say that's at 6 weeks, there is life there. And that's why you have to have an abortion before 6 weeks. Now, women, abortion clinics are saying, are you kidding? Most people don't even know they're pregnant until after 6 weeks. Adam, you said before, 15, 13, 14, 15 is when most abortions take place anyway. But 6, you have to really ask yourself, I better get a pregnancy test because I only have 6 weeks for this. So the Texas case is in effect The other cases have all been enjoined, right, in part because they're unconstitutional, according to Roe v. Wade. What happened that made it possible for the Supreme Court this summer to not even hear it as an emergency petition? Because if it is so obviously unconstitutional, why didn't they just say this is why none of the other states with fetal heartbeat laws have ever been implemented or enacted or gone into effect? Because it's unconstitutional. What happened this time?
Let me just say a quick word about fetal heartbeat. Most scientists say that's a misnomer. This is cardiac activity in the sense of an electrical current, but it's not a heartbeat in the usual sense, but it is 6 weeks. What Texas did was, extremely clever. It said it would ban abortions after 6 weeks, but it specifically said that no state official would have any role in doing this. It would deputize citizens in Texas and elsewhere to sue for damages themselves and incentivize them by giving them a $10,000 bounty if they won and their attorney's fees, whereas the defendants would not get their corresponding attorney's fees.
And who would they sue? Who would they sue?
They would sue anyone who, not the woman or pregnant person.
By the way, that's clever also, right?
Right, yes. but any abortion provider, anybody who pays for an abortion, anybody who helps the person get an abortion, the Uber driver who takes the pregnant person to the clinic can all be sued and be at risk of getting sued by countless people all over the state.
And this, again, this is not a criminal matter, it's a civil matter.
Right. Now, the usual way you challenge a law before it's enforced is to sue the state official in charge of enforcing the law, the attorney general, the governor. But this law was constructed in a way that you can't do the usual thing. So abortion providers tried to sue every court clerk and every judge in the state, and that goes up to the Supreme Court. And in a 5-4 ruling, without saying the law was constitutional, but just saying that the abortion providers had not overcome various procedural hurdles in the case, by a 5-4 vote with the Chief Justice and the 3 liberals in dissent, the court let the law go into effect September 1 of this year. So we're months into a look at what post-Roe abortion will be like in the nation's second most populous state, Texas. And what we're seeing is that the number of abortions has dropped precipitously. Some women are getting abortions earlier. Some women are going out of state to Oklahoma and elsewhere to get their abortions. And the number of legal abortions has dropped by maybe half.
So given the cleverness of what you said that Texas did, which essentially made the Supreme Court say, I don't know if we have procedural jurisdiction to get, we don't even know if we can talk about a case like this. Does it mean that this clever case, regardless of what happens in Mississippi, could also make it to the Supreme Court? Is it on the road? Is it being considered for that?
It's not only on the road, but it was argued on November 1st on an expedited basis.
So the case has already actually, even before Mississippi, this case was argued before the Supreme Court.
Yes, and I had expected the court, having expedited the case, to issue a ruling before the Mississippi case. That didn't happen. The court just this afternoon announced that it's going to issue some decision, one or more decisions tomorrow. The Texas case could well come tomorrow. I mean, I would expect, judging from the argument in those cases, there was a separate case brought by the Justice Department, that the court might well at least allow somebody to sue, not get to the constitutional issue, but just say, listen, you can't outsmart the Supreme Court. Federal courts do have a role to play here. And so I think it's possible, and it's possible fairly soon, that the Texas case will get back up on its feet.
And it gets on its feet only by coming up with a way to overcome this procedural hurdle. It doesn't, no matter what it does, if it say it was decided tomorrow that it came out, if we read you tomorrow, you would not say this decision effectively changes the Mississippi case.
Oh, no, no. I mean, the very most that could happen is the court sends it back down to the lower courts, says that either abortion providers or DOJ or both can sue, let the case go ahead, and maybe in the meantime block the law.
Huh. All right, we're going to take a question from the audience and we're going to say goodnight to Adam. Adam, this was an incredibly exceptional tutorial on abortion rights.
A lot of fun to talk with you, Thane.
I always enjoy having you as our guest. You're just a treasure. And this friendship is important to me, and your friendship with folks is very important to me. So thank you very much, Adam. The question comes from the audience. Let's see, I had it a moment ago. It was something I wanted to ask too, but I'm going to credit it for Barbara Whitaker, who I think was a law professor perhaps somewhere. Her question is, what are your thoughts about increasing the size of the Supreme Court? And the reason I think Barbara wants to know in particular is because wasn't it just yesterday that President Biden's commission on the Supreme Court actually provided its whatever recommendations. I'm not sure what it was authorized to do, but apparently in this recommendation or in this study that they performed is the idea, I think, not without some conflict among them, to increase the size of the Supreme Court. Now, I think maybe you could just explain that this has been tried before and what are the consequences of this?
Well, the size of the court is set by Congress. Nobody disputes that. And Congress, if it wanted to, could increase or decrease it. It's been as many as 10 members, as few as 5. I think you have to read between the lines of the commission's report because they didn't issue outright recommendations. But there was a significant fear that increasing the size of the court for political reasons, perhaps good political reasons, but nonetheless political reasons, would be a first step in a tit for tat that would really destroy the legitimacy of the court. And if people are in the market for ways to overhaul the Supreme Court, a more modest, in a sense, idea would be to impose term limits and not have as much happenstance, not have Donald Trump get 3 appointees and each of Presidents Obama and Clinton over 8 years, not 4 years, get only 2 appointees or 1 per term. So if you regularized through term limits court appointments, that would be a step, but that probably requires a constitutional amendment, which is a complete non-starter.
Right. Although it dawned on me as you were talking that it would do something that we've gotten used to, which is, I think in many years ago, like for instance, Benjamin Cardozo was finally elevated from the New York Court of Appeals to the Supreme Court. He was only a Supreme Court justice for a very short time, and he was elderly. It's only in the recent era that everyone talks, hey, let's put someone on the court who's 46 years old, because then they could serve 50 years, right? If they did term limits, you could imagine actually putting people on the court my age.
Yes,
right?
That's a good point.
You know, you could actually not, it's like you're gaming the system, taking advantage of the lifetime appointment, which I don't think was always true, but has become true.
Well, your basic point is right. Now, on the one hand, the median age of Supreme Court appointments is hovered around 53 through the life of the Republic. But the life expectancy used to be, you know, if you put a 55-year-old on the court, that person wouldn't be allowed that long. Mm-hmm. Now you have Justice Stevens retiring at age 90. Right.
Well, okay, Adam, that was just sensational. Before we say goodnight, I want to apologize to the audience for my disappearing, there it is, it's disappearing again, my disappearing background as I use the word shadows and penumbras. There were penumbras and shadows for tonight's inaugural headline series. I'm sure my background will return before I say goodnight to you in a few minutes. But Adam, before I say goodnight to you, let me see. We have a few upcoming events. We have something next week. Yep. FOLCS film series next week, a film, The Novice, a brand new film. Some of you will be able to watch it, advanced screening of it. We'll have the director, Lauren Hadaway, and the star, Isabel Furman, with us. It's co-produced with IFC, our producing partner. And then I think the week thereafter, there we go, our FOLCS Conversation series. As you know, we sometimes do books. This is the always charming, funny, hilarious Gary Steingart's new novel, Our Country Friends. It just so happens tonight's guest, Adam Liptak is actually said he's halfway through the book. So
Terrific book.
He's recommending the book. He's actually reading it, and I didn't know that he's reading it. And that event is the 21st. So that's on a Tuesday, and next week's film series is on Thursday. Let's see. Anything else? Yes, it's coming to the end of the year. If you're thinking of making year-end donations to worthy nonprofits, please think of us fondly. We think of you fondly. Adam, thank you again. We hope to see you again in July for Law of the Land.
Great to be with you.
We read you truly religiously, and you're an invaluable resource for all of us, and an incredibly valuable friend. Thank you, Adam. I'm Thane Rosenbaum for FOLCS. Until next time, good night.
Right.